Right.
Oh, you are there. Right. Okay.
Yeah, let's start.
Good evening. I warmly welcome you all to this webinar organized by the Colombo Law Society together with USA, COJASIS project of USAID. I'm Vijay Gamage. I'm the president of the Colombo Law Society. Colombo Law Society is the largest branch association of the Bar Association of Sri Lanka. Presently, we have a membership of around 4,000. This webinar is organized as part of our continuing legal education program, where our aim is to enhance the skill, the knowledge, and the competency of our membership as well as the legal fraternity. The COJASIS project of USAID has been assisting us with our continuing legal education program since April last year. They have immensely assisted us in developing our CLE policy. Together with COJASIS project, we were able to launch the very first webinar in the legal field, that is in April 2020. Since then, we have conducted about 37 webinars with them. So I would like to thank the COJASIS team, Chief of Party, Mr. Emery Adaradio, then Mrs. Shirani Narayana, Ms. Nimali Jayakodi, Mr. Roshanga Vikramsinghe, and Ms. Lakmali Kotalau. Thank you very much. This webinar is organized by our seminar subcommittee, where the co-chairs are Mr. Sanath Karunaratne and Mr. Chatur Galhen. I thank them for their hard work. Today, we have two giants of the legal field as our speakers. The present President of the Bar Association of Sri Lanka, Mr. Salya Peiris, President's Council, and Honorable M.S. Sumantiran, President's Council, Member of Parliament. Our moderator will introduce them. Therefore, I'm not going to say much about them, but we consider it a privilege to host both Mr. Salya Peiris and Mr. Sumantiran. Finally, I thank you all for joining with us. And now I invite our moderator, Mr. Sanath Karunaratne, our Secretary of the Colombo Law Society, to take on the proceedings here. Thank you.
Mr. Karunaratne, your microphone is muted.
Sorry. Before commencing the proceedings, I will briefly state how this presentation will go on. The two speakers will take about 1 hour to make their presentations, and thereafter we move on to a question and answer session. All the participants can post their questions on the public chat, which is on the left-hand side of your screen. And then I will post the questions to the presenters as the moderator, and thereafter your mics will be unmuted for you all to directly put forward your questions to the presenters. As you know, the topic today is fundamental rights and social media, which is a very interesting topic of the day. And I must say that upholding of fundamental rights always promotes better governance in any country. Now I will introduce the speakers. Mr. Salih Peiris, President's Counsel, is the President of the Bar Association of Sri Lanka. He heads his law chambers practicing in the areas of criminal law, public law, and fundamental rights in the appellate and original courts. From February 2018 to September 2020, he functioned as the first chairman of the Office on Missing Persons, a new institution established as part of the Sri Lanka's reconciliation mechanism. Between October 2015 to March 2018, he was a member of the Human Rights Commission of Sri Lanka. He was Deputy President of the Bar Association of Sri Lanka from 2015 to 2017. He holds a master's degree and master's degree in international business law from the University of London, and he earned his LLB degree also from the University of London. Other speaker this evening is Honorable M.A. Sumandiran, President's Counsel. He earned his bachelor's degree from the University of Madras in 1986 in BS in Physics. Attorney at Law of the Supreme Court of Sri Lanka, and he earned his LLM in Internet and Electronic Law from the Monash University, Australia in 2001. He is a Member of Parliament from April 2010 to date from Tamil National Alliance in the Jaffna district. He was called to the bar in 1991 and had been involved as legal counsel, appearing in all courts in the hierarchy, especially in the Apex Forum. Now I call upon Mr. M.A. Sumandiran to commence his presentation. Over to you.
Thank you very much. I must thank the Colombo Law Society and USAID for hosting this timely topic for discussion today. And thank you also for inviting me to share my thoughts. As Mr. Sanaratne intimated, both Mr. Peiris and I will share certain different aspects with regard to this topic. Mr. Peiris will deal with the development of the law in this regard and judgments, recent judgments, and so on. So I won't traverse that very much, except to say that as most of you will know, that fundamental rights is a chapter in our Constitution, Chapter 3. It runs from Article 10 onwards up to Article 17. And the discussion that we're having at present deals mostly with Article 14(1)(a), which says every citizen is entitled to the freedom of speech and expression, including publication. Of course, there are a few other fundamental rights also that might be relevant to this, particularly Article 10, which says every person is entitled to freedom of thought, conscience, and religion. Because of freedom of thought comes in there. And also Article 12.1, which is an all-encompassing fundamental right, as it were, that all persons are equal before the law and are entitled to the equal protection of the law. Some of the aspects that I will be covering will also entail considerations of Article 13 because of some of the arrests and so on due to social media postings in recent times. With regard to the broad gamut of Article 14.1a, that says that every citizen is entitled to freedom of speech and expression, including publication. Now, the word publication is very broad. That will include publication through social media, although social media perhaps was not in contemplation when this was drafted. In any case, many of these articles in our fundamental rights chapter were borrowed from international instruments. They were not drafted here. Verbatim introduced from international instruments. Nevertheless, it's broad enough to include social media which goes public. Now, this fundamental right can be restricted, and the restrictions that can be imposed are set out in Article 15.2 and Article 15.7. 15.2 deals specifically with regard to 14.1a, and 15.7 is a general one which includes Article 14 as a whole amongst other articles. But significant feature of these two restrictive provisions is that you can restrict it only by law. And law there would mean laws passed by Parliament. And for in 15.7 it says, for the purpose of this chapter, even emergency regulations will be considered law, but not otherwise, not administrative circulars or other kinds of directives that are issued. It must be law. One of the features of social media as we have it today is that this is a phenomenon that is very difficult to regulate by its very nature. I was introduced as having a master's degree in Internet and Electronic Law, and I remember 20 years ago when I followed this course, in Australia, in a lot of the Western jurisdictions, people are very concerned about privacy. And whenever this issue of privacy came up in class discussions, there was a gentleman in the class who would always say, no, there is nothing called privacy on the internet. Internet is a public place. If you don't want to do anything in public, don't do it in internet. Because whatever anyone might say with regard to security, confidentiality, privacy, etc., all that is technology related. You only have to take the word of somebody says that this is a secure connection, or this cannot be broken into, hacked into, and all of that. So that's one aspect. The other is, unlike print media or electronic media like radio or television, which all must be licensed, registered and has persons who can be held responsible for those publications. Social media is very, very difficult to regulate in that way. And so there are generally calls for regulation of the social media. Whilst that may be necessary in certain instances, the very availability of a medium called social media has today enhanced the exercise of the right of expression, the freedom of expression. It has enhanced it in leaps and bounds and broken so many barriers that I would think that it'll be a pity if we are to restrain that in some way. Of course, persons may have to be held responsible for certain types of publications on social media, and even criminally liable in instances where it instigates violence, hate, and violates certain fundamental privacies. But overall, governments have found it difficult to keep repressive regimes in place, to keep a tab on news, controlled news, because of the prevalence of social media, and that's a good thing. People are entitled to know what's happening. The freedom of expression, our courts, Supreme Court has held, includes the freedom to receive information. You can't actively exercise the right of expression and publication unless you have information. So intrinsic in this particular right is the right to receive information, and only if you freely receive information, news, then you can effectively exercise this fundamental right. So to that extent, it is enhanced. No government or any other person can stifle news, can do a blackout. Today, with the presence of CCTV cameras and social media, any crime that is committed on the streets can very easily be tracked, can be brought to the notice of authorities, and authorities have to act. One of the instances, most recent that I found, was today in the newspapers. The army has said that they have transferred 2 soldiers out of that particular area, and that they are going to hold an inquiry into an incident the previous day in Erawur, where persons who got on the streets to buy medicine and other essentials were asked to kneel on the streets with their hands raised. Now, that became imperative because that was possible because of social media, because these pictures were shared on social media, and they had to do that. I was just thinking back, maybe 10 years, just a decade ago, I mean, this wouldn't have been possible. Army would have flatly refused that such a thing ever happened. Worse things have happened which have been denied, because in those times there was no presence of social media through which medium you could actually disseminate the information to many people as possible. So it's not just crime by adverse elements of to society, but even instances where the protectors of the law or enforcers of certain rules and regulations themselves violate it, it is only social media that will bring that out. Mainline media, as regimes become more repressive, mainline media has a particular, they follow a particular path of self-censorship. Social media doesn't have that constraint and are able to giving out a lot of the matters to the public to know, except that in some instances they do it anonymously. So this is one of the problems that you have, because then behind the disseminated information, nobody takes responsibility. But I would think that in some extreme cases, you do need anonymous information to come out, and then it is up to the hearers to discern and find out whether that is true or false. Because if that information does not come out in that way, that can cause greater harm. So social media is a great instrument, but as it is with any great instruments, it also lends itself to greater abuse. The greater the usefulness of the tool, the greater the potential to abuse it also. So while people find this an effective tool in certain circumstances where there is no other way of bringing out information which can remedy injustice and so on, people also find it sometimes to be at the other end, where irresponsible use of the social media can damage people's reputation unfairly and so on. So in order to find a neat balance, I would say that, well, regulation is necessary, but that regulation should never be or never result in stifling or in any manner bringing about a chilling effect, so that people will be scared to disseminate truth. What they should be scared about after regulations come in is to disseminate falsehood. So that is the challenge for lawmakers and bar association and lawyers in general also must give thought to this very deeply, because this is a feature of great potential that aids our freedoms, for us to preserve our freedoms, and effective use of that without and minimize the negative incidents of it will greatly enhance our own fundamental rights. Thank you very much.
Mr. Sumandiran. Now I invite Mr. Salya Piris, President's Counsel, to commence his presentation.
Thank you. And first of all, let me thank the Colombo Law Society and USAID, the Co-Justice Project, for this timely timely webinar on the freedom of expression. Now, my probably I will overlap somewhat with what Mr. Sumandiran has stated. Now, essentially, first of all, just let us see what this freedom of expression. We all know what freedom of expression is. It is safeguarded by Article 14(1) of the Constitution. And just let's see what Article 14(1) of the Constitution says. Every citizen is entitled to the freedom of speech and expression, including publication. Now, one of the important cases where this issue of the freedom of expression was dealt with was the case of Joseph Pereira versus the Attorney General. Now, in that case, in Joseph Pereira versus the Attorney General, the case was relating to the Revolutionary Communist League. It is commonly known as the Vikosa or Viplavakari Communist Sangamaya. And the Vikosa had there was a meeting in Chilam, and there were leaflets which were distributed, which were critical of the then government. And the leaflet called out, invited the people for a particular meeting at the town hall, and it was quite sharp. It was sharply critical of the government of the day, and not only of the government of the day, but it also was critical of certain members of the Catholic clergy in Chilam. Now, before the meeting started, the police came in, dispersed the meeting, and arrested the persons who had organized the meeting. And ultimately, that was, in fact, one of the petitioners was the leader of later on was a presidential candidate of the Socialist Equality Party, Vijay Dias. There were three petitioners. Joseph Pereira was the first petitioner. So in that case, it was a 5-judge bench of the Supreme Court. It's the court observed that sets out the framework as to what constitutes the freedom of speech and expression. So this is what the court said in Joseph Pereira. Freedom of speech and expression means the right to express one's convictions and opinions freely by word of mouth, writing, printing, pictures, or any other mode. The right to express one's convictions and opinions freely by word of mouth, writing, pictures, or any other mode. So, although social media was certainly not in contemplation at that time, social media gets caught up in this. And it says it includes the expression of one's ideas through banners, posters, signs, etc. It includes the freedom of discussion and dissemination of knowledge. So what is important is, when we talk of the freedom of expression, and especially freedom of expression through the social media, it is important that we realize that it includes the freedom of discussion and dissemination of knowledge, especially at times of crisis in a country. The freedom to discuss, the freedom to share knowledge, freedom to agree, to disagree, ought to be protected. So the freedom of in Joseph Pereira, the Supreme Court said that it includes the freedom of the press and propagation of ideas. And this freedom is ensured by the freedom of circulation. So this is in essence what freedom of speech is all about. Now, if we go to Article 4D of the Constitution, we know that no fundamental right can be suspended. The Constitution does not allow suspension of any of the provisions of the Constitution. Fundamental rights can be abridged, restricted, or denied, and that is to the extent provided by the Constitution. Only to the extent provided by the Constitution. Now, the two limbs on restricting on fundamental rights found in Article 15(2) of the Constitution, the exercise and operation of the fundamental rights declared and recognized by Article 14(1)(a) is subject to such restrictions as may be prescribed by law in the interests of racial and religious harmony in relation to parliamentary privilege, contempt of court, defamation, or incitement to an offence. Now, if you contrast this with Article 15.7, Article 15.7 relates to the exercise and operation of all fundamental rights declared and recognized by articles, among others, Article 48, shall be subject to such restriction as may be prescribed by law in the interests of national security, public order, and the protection of public health, morality, etc. Now, if you look at 50, I just go back to the slide on 15.2. 15.2, when it comes to racial and religious harmony, parliamentary privilege, contempt of court, defamation, or an incitement to an offence, it says that the restrictions shall be subject to such restrictions as may be prescribed by law. Now, 15.7, in contrast, expands the law to include regulations made under the law for the time being in relation to public security. So, on one hand, when it comes to things like contempt, defamation, then the restriction has to be by law, essentially by legislation, or the of course we know that things like defamation, the common law would come in. But in 15.7, if it's in the interest of national security and public order, emergency regulations are also included. So, what would be important for us to remember is that although the Constitution prescribes a way to restrict fundamental rights, the restrictions are valid only insofar as they are necessary to achieve the object of the restriction. Now, in Joseph Pereira's case, when the Supreme Court analyzed the emergency regulations, and the Supreme Court concluded that the emergency regulations existed for the protection of public order, but the rest of Joseph Pereira and two others were for disseminating information or disseminating a leaflet, having a meeting, which was critical of the government, but which did not amount to harming public order. So any restriction which is imposed has to be reasonable, and there has to be a nexus between the restriction imposed and what is sought to be achieved. Now, this is important because today we see that there is always a risk that under the guise of the law, there is room for abuse where the executive, or especially the police, may sometimes try to stifle freedom of expression. Especially freedom of expression on the social media can sometimes be stifled by the police under the guise of saying that it is to protect, say for instance, under the guise of saying that it is to protect the people from the spread of COVID. You arrest a person, but really the arrest is done not to prevent the spread of COVID, but to prevent a person from expressing his views or from expressing dissent. So this is something which I think we must be aware of. Now, these are some of the laws which are cited by the authorities to restrict the freedom of expression. Section 120 of the Penal Code, Section 6 of the Computer Crimes Act, Section 98 of the Police Ordinance, Section 291A and 291B of the Penal Code, Section 3.1 of the ICCPR Act, and Section 2.1H of the Penal Code. I will briefly go through these laws. Section 120 of the Penal Code, I have it on the slide. Whoever by words either spoken or intended to be read, or by signs or by visible representations, or otherwise excites or attempts to excite feelings of disaffection to the President of the Government of the Republic, or excites or attempts to excite hatred or contempt of the administration of justice, or excites or attempts to excite the people of Sri Lanka to procure otherwise than by lawful means the alteration of any matter by law established, or attempts to raise discontent or disaffection among the people of Sri Lanka, or to promote feelings of ill will and hostility between different classes of such people, shall be punished with simple imprisonment for a term which may extend to 2 years. Now, sometimes the plain reading of this, one might feel tempted, or some police officer might feel tempted to think that this is that any criticism of the state, of the government, of the president, or of or that matter the administration of justice, that it would attract sanctions under the section 120 of the penal code. And so very often we see, recently we saw there was a police circular which was issued and which drew the attention of the public to these various sections of the law and said that the police are monitoring the internet. The police are monitoring the internet and they would be taking action against those who violate these laws. Now, if a person violates a law, there is nothing wrong in taking action. But what we, as citizens of this country, as people of this country, what we do need to be careful is that our freedom of expression is not stifled by officers who misunderstand the law or who choose to misapply the law and try to arrest people and take them into custody. So this is section 120 of the Penal Code. Then we have the Computer Crimes Act. We have the Computer Crimes Act. Any person who intentionally causes a computer to perform any function, knowing or having reason to believe that such function will result in danger or imminent danger to national security, national economy or public order, shall be guilty of an offence and shall on conviction be punishable, etc. Now, even this section is sometimes cited. The use of a computer, well, technically one might say even our phone today is a computer that we use when you're on Facebook, technically we might be using a computer, and then you cause a computer to perform a function when you send a message which affects public order. And some police officers argue that would become an offence under the Computer Crimes Act. Personally, I would think that when you look at this section, this is where, if for instance you use a computer, you use you use technology to hack, for example, I'm just giving an example, to hack, say the Colombo Stock Exchange, and you try to cause havoc in the trading of stocks. That might illegally you hack into a system. Then that might come within a person who uses a computer to perform a function which affects the national economy. But to say that using of Facebook or social media on a phone and to try to argue that comes within the Computer Crimes Act is, I think, reprehensible. Then you have section 98 of the Police Ordinance. Now, a person who spreads false reports with the view to alarm the inhabitants of any place within Sri Lanka and create panic. A person who spreads false reports with a view to alarm the inhabitants of any place within Sri Lanka. Those of us who are familiar with the riots of 1983, the riots happened over the weekend. After the first wave of riots, that Friday of the July 83 riots, there were people spreading news in Colombo, false reports, that the Tigers, the LTTE, had come to Colombo and were attacking people. Now that may be false reports with a view to alarm the inhabitants of a place within Sri Lanka and creating panic. But if I would say it would be a misuse of the police ordinance if one were to say merely posting something on social media, either on Facebook or Twitter, which may or may not be accurate, and to argue that is causing panic and alarming the inhabitants of Sri Lanka and creating panic, I think that would be an exaggeration. Now, what happened in Joseph Perra's case? Joseph Perra's case considered Regulation 26 of the Emergency Regulations. Now, there what the Regulation 26 said was, any person who by words, whether spoken or written, or by signs or visible representation, brings or attempts to bring the president or government into hatred, contempt, or excites or attempts to incite feelings, etc. D, raises or creates or attempts to raise or create discontent or disaffection among the inhabitants of Sri Lanka or any section, class or group of them shall be guilty of an offence. So somewhat similar to section 120 of the Penal Code. Now, so in Joseph Pereira's case, the Supreme Court looked at it, looked at the pamphlet which had been distributed, strongly criticizing the government, attacking the government of the day, and asking the people to rally against the government. And the Supreme Court said this: the comment may be strongly worded, but it does not have the pernicious tendency. Sorry. The comment may be strongly worded, but it does not have the pernicious tendency or intention of creating public disorder or disturbance. The pamphlet is not couched in any language calculated to incite persons to action. There is no advocacy of action. So, a mere report, a mere post on social media, which may incite ill will towards any government of the day, is not will not be something which necessarily is intended to create public order or public disturbance. So, on one hand, if a leaflet incites rebellion, or if a leaflet incites the members of the public to commit violence, that may come within section 120. But mere strong words, mere strong criticism of the government alone would not come within this the limitations found in 15.2 and 15.7. And in Joseph Pereira's case, the court observed, it certainly contains expression of dissent and criticism against the government. The police should not be timorous to send. This is so very important, this line. The police should not be timorous to send in every utterance criticism of the government, an attempt to incite disaffection against or to overthrow the government. The police should not be timorous to send in every utterance of criticism of the government, an attempt to incite disaffection against or to overthrow the government. It is to be noted, what is prohibited is advocacy of action and not advocacy of ideas. Only when the speech is an integral part of action does it become penalized. Now, the court also looked at this issue of what is the truth. Now, very often we sometimes see people, the executive, saying, this is fake, this is false. Now, what is the truth? Freedom of discussion must embrace all issues. Freedom of discussion must embrace all issues about which information is needed to enable the members of a society to cope with the exigencies of their period. It is essential to enlighten public opinion in a democratic state. It cannot be curtailed without affecting the right of the people to be informed through sources independent of the government concerning matters of public interest. So it is very important to realize that there is no monopoly of the truth. No one person can claim to be the repository of the truth. Sometimes the truth, certain posts, certain articles, certain utterances may at first glance seem false. But if it is probed, if it is inquired into, if it is looked at, it might very well be the truth. So what is important is one cannot have a police officer. One cannot have a police officer deciding on what is the truth. One cannot have a member of the judiciary deciding at the outset as to what is the truth. So especially at a time when there is a threat that a person might be arrested for posting something false or something untrue. The question is, who decides on whether that statement is true or not? Now, we all know that in China, that during the first signs of the pandemic, the certain doctors who commented, who tried to inform the world of what was happening, that first of all, they were branded as persons who were spreading fake news. They were probed, they were questioned. So it is so very important. Now, this is from Joseph Pereira. What is the truth? It is so important in a democratic society that there is discussion. And sometimes the truth can be understood only by a process of dissemination of information. So if one were to stifle at the outset, if the executive were to stifle the release of information on the basis that that is fake, that would be, I think it would be dangerous for democracy. Now, the Supreme Court went on in Joseph Pereira's case to say there must be untrammeled publication of news and views and of opinions of political parties which are critical of the actions of the government and exposes its weaknesses. Governments must be prevented from assuming the guardianship of the public mind. Truth can be sifted out from falsehoods only if the government is vigorously and constantly cross-examined. Now, this judgment was in the 1990s, in the early 90s, but this is very, I'm sorry, in the late 80s, and this judgment is very important for the even today, that the governments can't assume that they are the guardians of the public mind. Governments are not necessarily the repositories of truth. And this is important. So whether it be mainstream media or social media, it is for us to understand this. Now, in a more recent judgment, in the case of Uwindu Kuruguru and JKW Jayasekara versus the Sri Lanka Rupavahini Corporation, the Supreme Court once again examined this. Now, in this case, what happened was there was a TV show on Rupavahini. Halfway through the discussion, when the petitioner, the first petitioner, voiced certain criticisms, the Rupavahini Corporation shut down, stopped the program. They stopped the program, and they halfway through the program, they terminated the program. So the petitioner, first petitioner was the participant. The second petitioner was a viewer. Now, this is what Justice Aluviharan, the court held that there was a violation of fundamental rights. Now, this is what Justice Aluviharan has observed in this judgment. Respondents have alleged that during the first round of the discussion, the petitioner deviated from the topic of discussion by making political speeches, alleging that the media was subject to self-censorship and referring to a pending court case against a journalist detained under the PTA. Now, this is what the judges observed. Having viewed the recording of the program, I observed that the petitioner did in fact make those statements, namely that Sri Lanka's global ranking in media had fallen from 52nd to 165th. Journalists had been murdered and kidnapped under the incumbent government. Journalists who wrote security analysis had been assaulted or threatened. There was a self-imposed censorship in the whole media sector. These regulations were being introduced during the tenure of a president who used to be a friend of the media, and that a journalist was being detained for more than 100 days without a hearing. Now, this was the observation of the court as to what the contents were. Now, this is what Justice Aluviharan went on to say. The judgments of the Supreme Court constitute a body of jurisprudence that has evolved over the years, and the Supreme Court has recognized the right to comment on public officials and public institutions is essential for the exercise of civil and political freedom so valued by a democratic society. So in this case, the Supreme Court held that the termination of the program was a violation of fundamental rights of the freedom of expression. Then the Supreme Court went on to observe the right to support or criticize governments and political parties, policies and programs is fundamental to the democratic way of life. And democracy requires not merely that dissent be tolerated, but that it be encouraged. Criticism of the government and of political parties and policies is per se a permissible exercise of the freedom of speech and expression under Article 14.A. So the framework of our constitution, of the jurisprudence, these are but a few cases. Justice Alvihara's judgment here is a number of cases on freedom of expression, but the Supreme Court continues to value the importance of dissent. It is in any democracy, dissent, it is important to protect the right to dissent, the right to disagree, the right to criticize. And you cannot protect that right if people are subject to arrest, subject to investigations over what they say. Because this is why time and again it has been warned that there is always a risk when certain sections of the law are used, that they have, and you have the threat of investigation, the threat of being summoned, that would stifle the freedom of expression. And as Joseph Perra, the court observed, that the freedom of expression is the right which leads to many other rights found in the Constitution. So we find that arrests by the police and threats of investigations may harass those who exercise their freedom of speech, may affect the rights of those who seek to express dissent, it will also may harass those who are whistleblowers, who wish to expose corruption of persons in authority. So it is absolutely important, especially the protection of people using the social media, because the social media is one important way of exposing those who are corrupt. And that is why sometimes people seek to do so anonymously. Of course, we know that there is another side to it. The other side to it is if a person is defamed as to what could be done. So we will come to that, we will discuss that. But here, as I said earlier, there can be no one person who has monopoly of the truth. And if people are arrested for fake news, for publishing news which it is alleged to be fake, there is a risk of police officers and sometimes even judges before whom they are produced of prejudging what the truth is. And that will have a chilling effect on the freedom of expression. So that is why time and again it has been warned that there is a risk of abuse of the process by police officers. Now, I want to say a few words about hate speech. There are several sections in the Penal Code about hate speech. Section 291A, 291B about with deliberate intention wounding religious feelings, deliberately and malicious intention of outraging religious feelings of a class of persons, 291A and 291B. Coupled with that, we have also the ICCPR Act. The ICCPR Act, as you are aware, is a tough act where bail is restricted. And what Section 3(1) of the ICCPR Act states that no person shall propagate war or advocate national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. And Section 3(2) makes it abetment, attempting, even threats to commit these acts punishable. So, the ICCPR Act, no person shall propagate war or advocate national, racial, or religious hatred. Similarly, there is another section, it's Section 21H of the Prevention of Terrorism Act. Again, whoever by words, written, spoken, etc., promotes terrorism, ill will between communities, so on, there is a section which criminalizes. Now, the dangers of criminalizing hate speech, and now very often we see this hate speech, or so-called hate speech, sometimes is portrayed on social media. Now, on one hand, there is a need to tackle hate speech, but on the other hand, the danger of criminalizing hate speech is that it is said that there is naturally a reluctance to entirely criminalize hate speech for fear that it would stifle freedom of expression and legitimate dissent. So, for example, a genuine critique of a religion criticism of a religious leader could be unfairly portrayed as hate speech. I have come across an instance where the police filed a B report where a particular journalist wrote an article in the Daily Mirror critical of a particular religious leader. And the police started a criminal investigation in respect of that article. Now, which was critical of a particular religious leader. Now, mere criticism of a religious leader, would it come within the provisions of the ICCPR? But the danger in this is, once you launch the investigation, you hold out a threat against people who are expressing their free views. So there is a risk of indiscriminate. There is also in respect of hate speech, there is a risk of indiscriminate or targeted use of hate speech provisions. One of the allegations in respect of the use of the ICCPR Act is that it has been selectively used. There is an allegation that the ICCPR has been used to target specific people, whereas it has failed to target others who may have incited violence based on race or religion. So that is one of the criticisms of the ICCPR. In 2001, in a joint statement, the UN, the OSCE and the OAS special mandates on the right to freedom of expression set out a number of conditions which hate speech laws should respect. And these are some of the conditions. No one should be penalized for statements which are true. No one should be penalized for the dissemination of hate speech unless it has been shown that they did so with the intention of inciting discrimination, hostility, or violence. The right of journalists to decide how best to communicate information and ideas to the public should be respected, particularly when they are reporting on racism and intolerance. And no one should be subject to prior censorship. And any imposition of sanctions by court should be in strict conformity with the principles of proportionality. So, with that, when we come to the social media, of course, the ordinary laws of the land would apply to those posting or sharing on social media. There is, if one were to post something which is defamatory, one would be exposed to the ordinary laws of defamation of the country. So whether you write to a newspaper and carry something defamatory, or you post on your Twitter or Facebook something which is defamatory, you would be open to a defamation suit. So defamation, court of contempt of court, laws relating to incitement to violence, these would apply. But one question which arises is, what do you do when people are defamed with fake profiles? If a post is false, if a post on social media is false, the person who is targeted may be able to sue for defamation. But there is also this other side, that sometimes social media could be used to change the mindset of people. So we know that the way in which President Trump used Twitter, social media was used to spread the story that the US elections were fraudulent, when in fact the President Trump's own Republican officials were rejecting that contention. We know that today a good 30% of Americans believe that the last presidential election in the United States was rigged. Now, there is a danger that social media could be misused. So we know that today the social media today users, sometimes certain posts are flagged as being fake news, as being untrue. And we do know that there is a risk of social media being misused, and we know that how many of our friends sometimes believe certain stories which are shared on WhatsApp and so on, which are absolutely fake. But people just tend to share these. Also, what about people who are targeted by false posts, fake posts on social media using fake profiles? What do you do in respect of fake profiles? Because very often there is no easy way to identify persons who are behind fake profiles. So we know that there is a system at the moment. The TRC makes requests to take down, but social media, which is operated in foreign countries, where in a sense the decisions have to be taken not within Sri Lanka, don't necessarily comply with the takedown requests. And at present in Sri Lanka, we do not have a framework in relation to social media. So that is one problem. But the other side of it is, if social media is overly regulated, there would be a stifling of the freedom of expression. So the freedom of expression is so very important in a nation that one has to be extremely careful that when laws are introduced to regulate social media, it may be under on the basis that you want to prevent fake news. But the question is, how do you decide what is fake, what is true? And are we going to leave it in the hands of a police officer to decide whether a person who posts something on social media is whether that what he posts is true or not true? And on that basis, would it be safe to allow people to be arrested? Would it be safe to allow courts to take an ex parte decision to order the taking down of certain posts? Because would we allow the courts to take a decision on what is true or not true right at the inception? That might ultimately lead to suppression of the truth, suppression of dissemination of ideas, and this is the dissemination of ideas. Dissent is a cornerstone of our democracy. So that is important. Fake news is nothing new. We now see fake news perhaps on social media, but during the 1980s or the 1970s, in 1970s there was no TV either. TV came into Sri Lanka in 1978. There was no internet. Most of the newspapers, media were regulated by the state, but still there were, by word of mouth, there used to be stories which would do the rounds. Some of those stories would have been true, some not true. But to what extent do we allow the state to regulate the spread of ideas and views? So these are a few thoughts on freedom of expression and social media. Thank you.
Thank you very much. Thank you very much, Mr. Piris, for your very insightful, thought-provoking presentation. Now we move on to the question and answer session with the questions which have been forwarded by the audience. Can you hear me now? Yeah.
Yes.
How can we ensure dignity for all human beings? How can we protect people from their political leaders? How can we protect minorities from majoritarian whims? How can we establish institutional touchstones to support vibrant civil societies? Or shall we take one by one?
Yes, I think some of these are very broad questions.
Yes.
I would like to answer the last one first.
Yes.
do you think ones who are fake without identity in social media can claim rights given to a citizen? Well, the question is this. There may be certain people who wish to remain anonymous. Now, there may be certain people in certain situations, they cannot make their names known. So, for example, what we know people who are called whistleblowers, people who are in possession of important information which exposes corruption. But because of their status, maybe they are employees of the state, they are employed in a particular place, they cannot come out and give information because their jobs may be at risk, their safety may be at risk. Are we going to prevent, simply dismiss them as being anonymous or fake? Or is it what is necessary? Is it the message or the messenger? My position is, we must be careful. You know that there is the famous story that sometimes people tend to kill the messenger. The person who brings the message should not be. You must look at what is the message. So if in an anonymous profile, if something valid is raised, one cannot say, well, he is not a citizen, he should not be heard. But you must look at so this is where discussion is important. And if you have freedom to discuss, freedom of debate, the truth will, my view is that the truth will finally emerge. Of course, that is not to say that I do agree that there is a problem on social media that people can, under cover of a fake profile, target people. Individuals can be targeted, and that can have an impact on them, on their families, on their privacy. That is certainly an issue and something which must be thrashed out, which must be looked at. But when you are doing that, excessive use of the law, stifling freedom of expression is not the way to go. Because if you value your democracy, if you value the freedom of expressing yourself, then you cannot allow a state at every turn to just use fake news and stifle freedom of expression. So this is where, of course, there is a conflict, because in the traditional media, in the traditional newspapers, you always had a publisher, you had an author, but here the author is anonymous. But there are certain situations where people might have to decide to be anonymous for their safety, for their job security. So I think there must be a balance between in recognizing that there may be instances where people in good faith choose to be anonymous, and one cannot try to stifle them unduly. Then as to the next question, sorry, I think there were a few other questions.
Yeah.
How do we ensure dignity for human beings? Well, once again, this is a very broad question, but I think so. One problem with social media is about certain profiles or certain pages. People post things which are defamatory, which affect people's privacy, and that is where I think there must be for instance, if there is a social media post which affects the privacy of a person, and there could be ways of going to court. There are, at the moment in Sri Lanka, there are no laws to this effect, but you can seek ways of going into court to try to give a takedown request. At the moment, the TRC sends takedown requests, but there is no legal framework. So I think that is important to bring in a framework, but in bringing that framework, it must be done very, very carefully, because it's not allow laws relating to fake news be used to suppress dissent. And certain countries of East Asia, Southeast Asia are not the best examples of dissent. So that is, you have to be very careful. I don't think, how can we protect minorities from majoritarian views? Well, again, freedom of expression. The question of hate speech is one issue. The question of hate speech, where hate speech, social media, we saw sometimes a particular community is targeted using social media. And there may be a need to enforce hate speech laws. But again, what we have seen is the ICCPR Act is sometimes not being used in a fair manner, and it is targeted. The Act is there, but the use of the ICCPR is not really to protect a particular community, a minority community, from undue attack. But here again, we must also understand legitimate criticism of any religion, any community, whether it be a majority or minority, legitimate criticism has to be permitted. So, for example, you might have a debate on the age of marriage. That is a legitimate debate. So that I don't think, under the guise of protecting a minority, that you can prevent that from being debated. I think we can get on to the next questions.
Yes. In Sri Lanka,
Yes.
there was a period where there was a blanket shutdown on social media by the government. Example, WhatsApp, Facebook, etc. Is this a violation of citizens' rights to expression, or can it be restricted on national security?
Well, once again, on the grounds of national security, if one looks at Article 15(7) of the Constitution, there is provision at a time of grave emergency. What Article 15(7) says, this shall be subject to restrictions as may be prescribed by law in the interest of national security, public order. So at the point when WhatsApp and Facebook were sometimes shut down, the government, of course, we know that people use VPN. But there, I think the government had a legitimate concern, because we saw that we all witnessed that over a couple of 2-3 days, there was a hype on social media, on WhatsApp, Facebook, and when a restriction was imposed, there was things calmed down. So in my view, the government was within its rights to do that. But once again, it has to be backed by a law. It has to be either there must be a law in place, law passed by Parliament, or under the emergency regulations. So I don't think without a law in place, without emergency regulations or without legislation, that it cannot be left to an executive order alone, without backing of a law to shut down, to have a blanket shutdown. Because the risk there is, today it may be for a genuine effort to protect public order, it may be for a genuine national issue, but there can be another day when the executive decides that it does not want that it wants to stifle genuine criticism. So in that situation, there must be a law, and there must be to challenge any such orders.
Right. In India, the Tripura High Court has upheld the freedom of expression with regard to a social media post with regard to the Citizenship Act. With the decision of Justice Bandaranaike's impeachment judgment, has the judicial intervention been restricted, say to declare a new regulation, law, or law not to be published on social media illegal?
I'm not sure exactly what the right is. Well, I don't think Justice Bandaranaike's impeachment has any reflection on the freedom of expression. The judgment of Justice Aluvihara, which I cited, is a judgment of 2021. So I don't think you can say that because of the impeachment that the judiciary has been stifled. I don't think that you can say that.
Okay. Can a member of political party promote his party policies or current views against the prevailing government with regard to the critical issues being occurred in the country.
I don't think that is part of this, Sanath. I don't think that is part of this discussion. So I don't think that we need to go into that.
Thank you. If there is a, let's go on to the next one.
Yes.
If there is a post on public media, say a presidential commission appointment, say the post says that whole process is waste of time and public money, where does one draw the line between freedom of expression and contempt of court?
No, I think I would say that is freedom of expression. If you say the appointment of a particular presidential commission is a waste of time and public money, you are expressing there is no contempt of court there. There is no contempt of court. It is a legitimate opinion. I don't think I have not heard of any move to deal with such a comment for contempt of court.
Okay. Next one. Advocacy of separatism in local media or digital media is banned under Constitution. However, how is it possible newspapers publish articles against 13th Amendment or 16th Amendment, which are also part of the Constitution? Is it not double standard?
No, I think every person is entitled to express their opinions. So just because there is something in the Constitution, people are entitled to criticize any provision of the law. One can say that the provision of the Constitution, this provision of the law is not suitable. I don't see any double standards with that. Well, the ban against separatism is found in Article 157, where the 157A, what it says is no person shall directly or indirectly in or outside Sri Lanka support, espouse, promote, finance, encourage or advocate the establishment of a separate state. And then of course there is a process. If you violate the provisions, you can be subject to a trial. So espousing the cause, to directly or indirectly espousing the cause of separatism, separatism is an offense. So advocacy of separatism is a criminal offense in Sri Lanka. So you cannot compare it with someone criticizing either the 13th or 16th Amendment.
Okay. If any person share fake news through Facebook without knowledge whether it is true or false, maybe public awareness, is it punishable? Is it a punishable offense?
Well, if you share fake news, you share something which is defamatory, you are liable for defamation under the laws of defamation. If you share something, if you see on Facebook some post about another individual, you share it, you take responsibility, and you can be sued for defamation by that person. So similarly, so that in that sense, I think as citizens, as people, there must be a responsibility in sharing information. So if you share something seditious, so for example on Facebook, if someone there is a post which advocates violence, if someone advocates violence or even will assume to kill someone, and you decide to share it, you will be liable. Not only in this country, in many other countries. In the United Kingdom in 2010, there was a student riot. There were people who rioted. Within days or within hours, certain people who advocated, who incited violence, who shared posts inciting violence were arrested and dealt with. So you can't share information. If you share a post, you have to take responsibility for those posts.
Okay. Next one, attracting the ICCPR Act provisions for a social media post of a dead person, say extremist, by police, is it good in law?
Sanath, I do not understand the question. What I do think is, if what you say, what I can this thing, if you share a post, even of a dead person which espouses violence, you will be responsible. So if it's a
Some technical error. We'll have to hold on for a second.
I think we have lost Mr. Pires. He might log in again soon.
Yes. Participants, please hold with us for a moment.
sorry for the glitch.
Yes.
Yes.
No worries. Thank you, everyone.
Sorry.
Yes. May I read the next one?
Yes.
You have to allow the, yes. Can a person be charged for disseminating a piece of true news that is kept classified and disseminating which causes public unrest or excitement?
Well, there is a law relating to official secrets. Now, so for instance, issues relating to, for instance, an issue which relates to public security information. Disseminate, it may be true, but disseminating it will prejudice national security. There could be something which is classified. Similarly, there may be true news. For instance, under the Inland Revenue Act, officers of the Inland Revenue take an oath of secrecy. So you can't disclose what is in the files of the people who you attend to those files. Certain situations where disseminating a piece of true news might not be allowed under the law. That depends on the type of news and what the law is.
Okay. Some video clips may be edited in a way that misrepresents what was said and misleads people. Some videos may be edited with the obvious intention of being satirical. Given the difficulty of drawing a clear line between the two, especially where the public or police officers are making this call, do you think, on a balance, is it better to leave the space unregulated?
Well, I think that would depend on what the misrepresentation is. So, I mean, I don't think we can give one specific answer. I think that would very much depend on what the misrepresentation is, whether something is done as satire. And so that is important also to make that distinction. And so this is where I, for one, I am a little wary about criminalizing matters, because when you criminalize, defamation is a different thing. But when you criminalize, you have the risk of the executive moving in to stifle freedom of expression. We all know that from a long time there have been articles which are sometimes satirical. You know that in the 90s.
Sudden drop of signals, I believe.
I'm sorry. During the taking of the Dawasa, I think it was the sealing of the Dawasa newspaper. There was a well-known doctor who went to Lake House and gave a death notice. Death notice of a person called D.E.M. O'Crazy, and the death is announced of D.E.M. O'Crazy, beloved husband of T. Ruth, father of Faith, Hope and Justicia. Then said funeral at Araliya Madura, Panagiya Vatta, and that was published in the Daily News, obituary of democracy. Now it is only after that now they ask for the death certificate. Every time you go to publish an obituary, they want the death certificate after that incident. But that was satire. So you could not have arrested the doctor who went and gave that post, although it may be technically false or fake.
Under current law, is there any possibility to take action against journalists who spread fake news?
Well, we don't have laws of criminal defamation. There are no criminal defamation. But if there is a journalist who is making statements which are defamatory, you can proceed against them under the normal civil law of this country. Already in our courts, there are civil cases against journalists. People have filed civil cases against the newspapers, against journalists, and as in many other countries. So that is perfectly fine. That there is no prohibition. There is no prohibition of filing action. But it is a different thing to have criminal defamation, to try to hold the threat of criminal action, arrest against journalists is something I think which has to be, that would be problematic.
Okay. How much privacy protection a citizen has on his or her views expressed on Zoom, Microsoft Teams, and Clubhouse, etc.? Can the print media freely publish them, identifying the source without his or her consent?
Well, once again, I don't think we have regulations on these stuff, on these things. So there is nothing except for maybe what is ethical. there is no legal framework regulating this.
Yes. Can police take action against defamation case? That you
No, the criminal defamation has been in 2000, somewhere in 2001 or 2002, criminal defamation was abolished, was repealed. So now, if those of you may remember, the editor of the Sunday Times was indicted in the High Court for criminal defamation. And but since then, criminal defamation has been abolished. So now criminal defamation is not the problem. But police do make arrests under Section 120 of the Penal Code, ICCPR Act. Those provisions are sometimes used and arrests are done.
Right. Are there any guidelines for police officers in determining what incites violence? Can the judiciary formulate such guidelines?
Well, I think the case law which is in existence, there are sufficient guidelines. If one looks at what was stated by the Supreme Court in Joseph Pereira's case, is I think, and many other cases, I think those are quite sufficient for the police to understand what is and what are as to in what manner arrests can be made, where there is instigation for violence, to incite violence, so on.
As per the explanation of Section 120 of the Penal Code, people are not restricted in showcasing their views and thoughts on errors of defects in the government. However, will the section remain the same or applies in the same manner if such thoughts are expressed via social media? And do we have such freedom when it comes to the political situation? If not, shouldn't the laws be amended to address the practical issue?
Well, I think my view is that our laws, that the legal framework which is there in Sri Lanka is clear. But here it is not. The problem is not the legal. Maybe we need a clearer legal framework in relation to privacy, relating to social media. There might be need to be a legal framework because there are new issues to address. But if you take the ordinary, if you take the regular media, I think the legal framework is sufficient. But it is the tradition. We must have a tradition of tolerance, where the executive needs to understand that dissent is a good thing for a democracy. And in actual fact, dissent is good for a government. When there is dissent, when there is disagreement, when there is debate, that is good for a country. And that, in fact, that must be encouraged. And I think our laws are sufficient. The guidelines, the judgments of the Supreme Court, we have extensive judgments on this. And I think that is quite clear. But the problem is it is necessary for the police to understand that. And the police must not be used as a tool to stifle dissent.
Can we now open the forum for the participants to post their questions? Shangar?
Well, Akmal, can you open the mics? Mics are open.
Yes, the participants can, if they have any questions, they can directly put to Mr. Piris.
I wonder whether Mr. Sumanthiran is...
No. Yes. It seems no questions. Then I will start my last item for the day. Thank you very much, Mr. Piris and Mr. M.A. Sumandiran, President Council, and Mr. Piris, President Council, for your very thought-provoking, insightful, informative presentation. I think everyone today got their time's worth in this Monday evening. And I thank every one of you who participated in this webinar today. Without y'all, we wouldn't have had this successful session. And I especially thanks USAID Co-Justice Program who are co-hosting this program with us, and Emery Adoradio, Chief of Party of USAID Co-Justice, Nimali Jayakoti, Roshanga Vikramasinghe, Lakmali Kothalawala for their assistance. And let me thank President of the Colombo Law Society, Mr. Vijay Gamage, the two vice presidents, and the committee members, and my co-chair of the seminars committee, Mr. Chatura Galhena. And please join us for the next webinar on Sunday. Sunday is the day we have our webinars, though we had this webinar on Monday, and even the last week we resorted to have a webinar on Monday. And we would like to hear from you, the participants. You may forward your observations or your lovely comments to us by email to colombolawsociety@gmail.com. Thank you very much, everyone. Wish everyone a very nice evening. Thank you.
Thank you.
Lakmali, we can close now.